So competence is just one of the duties that a lawyer owes to the client. They also owe a duty of diligence as well. And by diligence, we mean they have the duty to, pursue matters in a faithful manner that is best not just for your client, but for the system of justice. So you can't just put things off again and again, hoping that a problem will go away. Diligence really means, in this particular, in considering the duties of a lawyer, is to be, have perseverance and to see the matter through. Now, a lawyer has a duty to communicate, and that seems pretty clear, right? But this is probably the most abused one of the duties that lawyers owe their clients. I do a top 10 annual roundup of the people who have been disciplined, the lawyers who've been disciplined in Texas, and the number one complaint that clients have about their lawyers is they fail to answer emails, fail to respond to phone calls. And, I can feel the pain of some lawyers because I was working at a legal clinic many, many years ago, and one of my clients had OCD, and she would call 200-300 times a day. And I, of course, could not answer every phone call, but you have a duty to make reasonable returns for requests for information. So I would tell her, listen, I know you get upset, so I'm going to call you every day at the same time, and that's it. She continued to call 200 or 300 times a day, but I would just call her once a day. Most clients would be happy if you called back in the day or two. And of course, respond to email and things like that. Another thing you have to do as a lawyer is, because you represent someone, and anytime you get any kind of communication on your client's behalf, you have to let them know. And that might be a court filing. It might be a message from the other party. It might just be money. Here, we've decided to pay up. You have to communicate anything you receive on behalf of the client as soon as you get it, reasonably soon after you get it. And that goes the other way too. Anything you're sending out on their behalf, you have to send them a copy. The duty for candid advice. You're going to be surprised by this. I know a lot of people are, but lawyers have a duty not to lie. Some of you, I'm just going to wait for the laughter to subside. But the duty to give candid advice is, of course, paramount to the client. You have to be honest with them. And sometimes that's difficult because sometimes you have to say things a client does not want to hear, but that's your job. To represent them fully, you must be honest about the potential success or lack of for the case that you're pursuing on behalf of the client. Now, I've been talking about a lawyer-client relationship kind of broadly. Lots of different types of relationships in terms of, we could have a corporate client we're doing transactional work for. You could also do litigation work for a corporate client. And of course, you could do family law, you could do general litigation, you can do wills and trusts. I mean, the relationship will look different with each of these. But all of these duties are appropriate to discuss in any one of those specialties. Division of authority. So some things the lawyer must follow the wishes of their client. The client always has the right to settle a suit or to bring it to trial. That's the client's choice. Now, sometimes it makes no sense to bring a case to trial, and a good lawyer will try to persuade their client, perhaps we should just settle this or let it go, because taking a case to trial, as you know, is very expensive. But if it's the client's wish to go to trial, then that's their choice. It's similar with a criminal case as well. It's their choice whether or not they want to plead guilty or not. It's also the client's decision whether or not to appeal. And for lawyers, they're responsible for making more of the strategic decisions. So if you're handling a case for someone and you're going to go through discovery is a process of getting information outside of the courtroom. And we'll talk more about that in practice of law. But in discovery, you might be taking depositions where you're, swearing someone in, and then you're asking them questions under oath and deciding, what depositions to take, what evidence to seek, what type of investigation you're going to make. Those are all decisions for the lawyer. Now, the model rules, the ABA model rules, and those are the rules that guide the behavior, or more than guide, I guess, the behavior of lawyers, says that even, if your client disagrees with your strategic decisions and what they want you to do is reasonable, you should probably listen to them. And of course, you have the final say on the strategic decisions a lawyer should make as a lawyer. But if their requests are not unreasonable, then you should really take your client's suggestions or wishes to heart. Now, the ABA model rules are just that. They are not binding on any particular state, but every state pretty much has adopted the ABA model rules in some form. So they're a little different from state to state, but for the most part, they're very similar. Some states have not followed the model rules, and so their rules look quite different. But these duties that we're talking about right now are very similar in all jurisdictions. These come from a long line of common law of lawyers' responsibilities. Finally, fees. I know everybody thinks this is when the lawyer starts salivating, and I have to admit, I get a little bit excited when I saw the word fees there. Lawyers' fees must not be unreasonable. Now, some of you who have hired lawyers are thinking, what? Well, maybe they're high sometimes, but what they can't be is like gouging of someone. Now, you know that, some law firm, big law firm partners, their hourly rate can be $500 or even more than that. Some super specialists were in the thousands per hour. But generally, when we're worried about fees, we're not worried about someone giving you an hourly rate, because you have to agree to that hourly rate as a client, and then you know what's going to happen. Another type of fee is called the contingency fee, and that's where a lawyer agrees to do a case for no recompense if indeed they don't win for you. So let's just say it was an automobile accident, and you hired a lawyer on a contingency fee basis to pursue your claim, and the lawyer is going to get 25% of whatever they recover. And so if you recover $100,000, the lawyer takes $25,000 and you get the rest. Now, you can bargain with your lawyer about this. You can decide who's going to pay the court costs, any investigation costs, anything. Is it going to be the net or the gross? And the ABA does not say, it can only be up to 33%. There is no limit. And the only limit is it must not be unreasonable. So it's all based upon a couple of things, but the experience of the lawyer, their success rate, what others normally charge. But the other important thing is with a contingency fee, the amount of risk that you won't win is going to give you a good reason to make the percentage of the lawyer's share of the recovery even higher. It's like in those tobacco cases. I don't know if you're following those way back, but I mean, for years and years, decades, lawyers were not winning any cases against tobacco companies. And still, some brave firms went after the big tobacco companies. And the settlement was so huge that the lawyers were supposed to get billions of dollars. A court actually trimmed quite a bit off of that because that fee was deemed to be not reasonable. But they still did pretty well. I don't think anybody expected to make billions of dollars on that. Maybe they did. That's just greedy.